like I said, I have plenty of time in order to work with this. I don't have to worry about it. And this is the results from Grok. Okay, so let's take a look. And again, Grok I haven't been using. I haven't. I've been using GPT. So everyone wanted me to send fresh information to Grok and redo things. So I did, and this is the result.
The police report from the October 2025 incident, case number FC 25-001-6140 details your attempt to serve a protection order on Robert Thayer after a courthouse hearing, which led to a harassment charge against you under Colorado law. Why prosecutors can't successfully charge you, high likelihood of dismissal or acquittal. Colorado's harassment statute, CRS 18-91101B-C, requires proving beyond a reasonable doubt that you followed Thayer with intent to harass, annoy, or alarm him. The report's narrative, written from Officer Jordan's perspective, relying heavily on Thayer's account, shows significant weaknesses. Lawful purpose undermines intent. You repeatedly stated your goal was to serve court papers, a protection order from an ongoing Larimer County case. You followed Thayer to the police department parking lot for a neutral location with witnesses, admitting this to officers. Colorado law allows personal service of process in public places, CRCP 4E, and courts recognize following for legitimate legal purposes isn't harassment if not primarily intended to annoy, alarm. Your actions align with attempting service after Thayer avoided it at court. Dispatch notes confirm he fled the hearing and you were trying to serve a prot order. No supporting conduct for intent. The report notes you were extremely animated and argumentative, but describes no threats, obscene language, physical contact, or repeated alarming behavior beyond following. Thayer's claims, e.g., safety concerns from your escalating behavior, online harassment, prior threats, are unsubstantiated here. Officers advised reviewing statutes and suggested Thayer pursue his own order, not immediate arrest. Public place and context. All following occurred on public roads, parking lots, post-hearing.
Here's the straight analysis. Scenario summary. There is an active personal protection order, PPO, against the defendant. After a court hearing, the plaintiff approaches or accosts the defendant in a parking lot to serve some non-court ordered notice. Defendant leaves in his car. Plaintiff chases the defendant on foot. Police intervene and ticket the plaintiff. Key points. 1. A PPO protects the plaintiff, not the defendant. The plaintiff is not violating the PPO by approaching the defendant. PPOs restrain the defendant's conduct only. 2. But the plaintiff can still commit independent offenses. Police aren't limited to PPO violations. If the plaintiff's conduct meets the elements of disorderly, obstructive, or unsafe behavior, they can be cited. 3. Plaintiff chasing a defendant who is driving away can look like disorderly conduct, creating a public disturbance, interfering with traffic, pedestrian violations, attempted improper service if they're serving something not permitted. Harassment, yes, plaintiffs can be cited for harassing defendants. 4. The plaintiff has no legal duty to serve non-court-ordered paperwork. And they definitely cannot use a courthouse parking lot confrontation to do it. Police will view it as escalation. 5. Courts and police expect the plaintiff to avoid conflict. When someone goes out of their way to charge after a defendant post-hearing, it looks aggressive, not protective. Bottom line, even though the PPO only binds the defendant, the plaintiff can absolutely be cited if their behavior creates a disturbance or safety issue, and chasing the defendant across a parking lot after court is going to get treated as exactly that. Let me know if you want this reframed for a motion, a police narrative analysis, or as part of a litigation strategy. Got it. Here's the clear legal breakdown. 1. Plaintiff cannot personally serve the defendant, period. In civil procedure, a party to the case cannot serve the opposing party themselves. Service must be done by a sheriff, a court-appointed process server, or any competent adult who is not a party to the action. So the plaintiff trying to hand the defendant anything related to the lawsuit is improper service and legally meaningless. Hammer 2. The court hasn't ordered service because the case hasn't passed screening. If the judge has not yet reviewed the complaint, no summons has been issued, no service is authorized, anything the plaintiff tried to serve is not valid. So the plaintiff had zero legal authority to approach the defendant at that moment. 3. Plaintiff's conduct is the problem, not the PPO. Even though the PPO restrains only the defendant, police still evaluate conduct independently. Here, the plaintiff approached a protected party, the defendant, tried to hand them improper legal documents, chased them as they retreated. This looks like harassment, disorderly conduct, attempting to escalate a confrontation immediately after a court hearing. The police ticketing the plaintiff makes sense. Courts expect plaintiffs, especially ones with PPOs, not to be the aggressor. Hasher 4. Plaintiff may have also jeopardized his own PPO credibility if the plaintiff is initiating contact, pursuing the defendant, or creating conflict. The judge may interpret that as undermining the necessity of the PPO or showing the plaintiff is using the PPO to harass or control the defendant. 5. Legally, the plaintiff had no right to serve, no authority to serve, and no business approaching the defendant. Bottom line. The plaintiff could not legally serve the defendant, had no court authorization to serve anything, initiated an unnecessary confrontation, acted in a way that police can and will cite, potentially weakened their own PPO position by pursuing the defendant. If you want, I can break this into a memorandum format, a litigation outline, or a police incident legal analysis.